something like that where you specifically disavow everything that's been said. And if you were at the complaint stage, the opposite would be true. You would want to allege everything you could, assuming it wasn't harmed by the contract. Would be my thoughts. Other thoughts? Because I think what these cases do is they open a big wide field for parole evidence now. And once you get that in on a point, how do you confine it to a point without getting a whole bunch of other stuff in? I think that while I understand the decisions here, I think these will serve to increase employment of lawyers' opportunities, both from the trying to get it in and the keeping it out stage. But those are some rather interesting cases because it over-abrogated, excuse me, I don't want to use the word. It did abrogate the prior rule that it's basically, can't have parole evidence. But now we can. Other fraud cases were fraud in the inducement. This case concerned allegations of actual fraud. And it could be said that it was fraud in the inducement because here, the plaintiff, who I'm not even going to attempt to spell correctly, the plaintiff had alleged that various representations had been made upon which he relied when he purchased a piece of property. In particular, what he alleged was that the property is in the hills, and access for utilities is challenging in the hills. Actually, once you get away from the established lines of power, utilities are very challenging. It used to be you could get power there and you pay a modest extra fee for the extra poles that had to go in. Not so much anymore today. Today, if you want to build a mile off the track, you're going to have to pay to get a mile's worth of telephone poles put in and then string the lines in. Well, here the problem was that the most direct route required power poles to go over Forest Service land. The plaintiff, thinking the government, while it is the epitome of reasonableness and understanding, might in this instance not be open to allowing power lines over its property. Anybody who's bought or done any deals in the hills knows that the Forest Service, basically their answer is no. And to get beyond that, it's a challenging thing. That said, I have had a number of successful interactions with the Forest Service and accomplishing some things and doing some land trades, but they start from no. So this purchaser wanted to be sure if he bought this, that he didn't get saddled with having to run a ton of power poles at a very great price. Because for most of you probably know if you've been in the hills, there's 1 inch of dirt over most of the hills, and then it's rock, so it's very expensive to get power poles in. Well, it was alleged that the realtor made affirmative representations that he had talked to the Forest Service and worked out the details, and there would be no problem in getting the power across the Forest Service land. Sale goes through. Construction starts, and it reaches the point where they need power, and the Forest Service went back to their usual response, which was no. And they never changed their mind. Negotiations failed. They were not able to get the power there. So now they've got a significant investment in land, materials, construction has started, and they have no power. So they had to go ahead and get an alternate route, an extra half mile of poles in the hills at a significant cost. So they brought this suit against Century 21 and against the realtor. And the question became, is this really a case about 3 years statute of limitations for real estate malpractice versus a 6-year for fraud? Well, guess who was arguing which? Plaintiff thought 6 years was good. The realtor and his company felt, no, this was clearly a case for real estate malpractice, and we're going to go along with those. Well, 6 years won, but only because the trial court had said no, 3 years of statute of limitations for malpractice covered it. So of course the appeal was taken, and there was much discussion by the Supreme Court in distinguishing what constitutes a malpractice claim. Now this context here was within the context of a real estate transaction. But some of the language, I believe, is broad enough that it can probably apply to other types of malpractice action. court commented that in this case it wasn't really for malpractice, error, mistake, or omission, which is the language of the malpractice statutes, but rather it was really a case of fraud. It wasn't malpractice because fraud isn't malpractice. And in the course of the discovery, the realtor admitted that he had not contacted anybody, and he admitted that he had lied about his representations, and he admitted that it was unlikely that the power would ever be allowed to cross over the Forest Service lands. So the plaintiff is undoubtedly thinking, we're empowered here, this is great testimony, this is what we need to show fraud. But then this company came back and says, no, this is 3-year professional negligence statute of limitations. Like I said, I think that has application to some of the other malpractice cases as to distinguishing between fraud and malpractice, but these facts were somewhat egregious. It's not often that you'll get a defendant who just seemingly without much difficulty admitted that he had lied and that his client, the purchaser, had indeed relied on it. So I presume when it goes back, I don't know what happened, but I suspect it probably got resolved because how do you get defended from it? So it would have come down to damages, and the damages amount wasn't reflected in the Supreme Court opinion, but they were clearly significant. Bertelsen versus Allstate Insurance. Okay, I like the insurance company. But I actually have this one stuck under more of a bad faith area, which is on page 2 of your materials. This is one of those cases that just keeps on giving employment to all the attorneys involved. This was the 3rd time around to the state Supreme Court, and the 3rd time it got sent back. There was allegations of bad faith, and the Supreme Court supported those allegations and said that those findings of bad faith were proper. There was evidence to support them. And then there's a long discussion, of course, that if you have punitive damages awards, that you can get attorney fees and you may be able to get punitive damages. Here, the jury awarded $1.5 million for punitive damages. Those got lost in the appeal. And they got lost because the jury came away with a misconception. The trial court refused to allow evidence to show that Allstate had in fact paid the claim, albeit too late to avoid the bad faith charges, but that they had paid the claim years earlier. So the jury was left with the perception that Allstate had in fact gone all these years and refused to make any payments. A reasonable jury would probably be a little bit annoyed at an insurance company for making an insured person wait so long. There was no effort to try and cure the jury of the misconception. The Supreme Court, not surprisingly, said, wait a minute, you can't allow that kind of a misconception. That the trial court should have allowed evidence in to say that they had gotten those payments made some years earlier. It would have reduced the time period down to about a year compared to the 5 or 6 years it was by the time the jury actually got to it. So it's a cautionary tale there. The cautionary tale on punitive damages generally is just kind of hard to get. And in truth, every single case is about damages. So I broke out these cases for your materials alphabetically by certain categories, but they could all have been lumped under damages. Nobody goes to court unless they're expecting a compensation of some sort. And in this case, they go back now and they'll have yet another trial. And then there was some discussion about whether bad faith by itself would get you attorney fees. Now, there were some significant attorney fees awarded in this case, but nowhere near the attorney fees that had been requested. There was an exhaustive review by the trial court of every single item for the attorney fees, and the trial court had accepted them all. However, the Supreme Court identified that many of the attorney fees that were associated with the jury verdict for bad faith, that was really related to the fact that the jury had a misconception of what was going on. And unfortunately, I think for the plaintiff, Those attorney fees at this stage of the game were not, in fact, permitted to be imposed on Allstate, because many of them related to a point on which the trial was reversed. But nevertheless, they did get significant fees. And the court said in several different ways that merely because you've shown bad faith by itself, that does not entitle you to attorney fees. Now, since this is going back for trial again, I suspect the issue is going to come back, so I think it's probably been delayed rather than resolved at that point. It seems to me a little bit broad to just say attorney fees, I mean, bad faith doesn't get you to attorney fees, you need something more. But I'm sure give ourselves another couple of years, we'll find out what, if anything, is that something more. There's an interesting and sad case that was decided, and it concerned attorney fees and receivership fees. This is another one of those difficult cases. It's on page 6 in your materials. This one has gone up on appeal for the third time. And the problem is really, at this stage of the game, what to do now. There was a dispute between various factions of the Hutterite community as to who controlled the assets, who controlled the company, how were they going to do things. Eventually it got to trial because the two factions simply could not resolve themselves. So it went to trial, and the court decided it's hopelessly deadlocked. We can't permit this. The corporation is paralyzed. As the community, it is not possible to operate any further. The question was in the first appeals, well, can you do that? Was this a secular court trying to inject itself into what's really a religious community issue? Is this really beyond the purview of state courts to examine? Well, it was determined that, indeed, a secular court, in other words, a trial court in this case, should not be injecting itself. Yes, perhaps the community was paralyzed. Yes, they couldn't do anything. Yes, they were fighting over the assets. People were allegations of people taking and hoarding assets and just general wrongdoing. But the Supreme Court said, no, this is really a religious dispute. And it was a religious dispute because they thought the community should be going in different ways. There was a separation of their philosophies. Nevertheless, it impacted all of their properties and holdings, which were held by the community, not individually. Well, it takes time for that to all process through on an appeal. So the trial court retained jurisdiction, which ordinarily you wouldn't be able to do once it goes to an appeal. Trial court doesn't get to do much else. But in this case, a receiver was appointed, and another appeal was taken concerning all of that. And by that time, one appeal has come back, one appeal is pending, and the first appeal comes back. So the trial court judge says, whoa, if I wasn't supposed to have gotten involved, what do I do now? I've appointed a receiver, I've appointed and approved attorney fees for the receiver, for the receiver's attorneys. What do we do? Not surprisingly, the trial court decided, the receiver did what he was asked to do. He's entitled to be paid for what he did. The attorney fees, those were reasonably incurred. And the court approved the receivership fees, attorney fees, and everything else in an effort to restore things back to where they were before the trial court injected itself in the first place. Well, that meant there's fewer dollars available. So another appeal is taken, saying that no, those monies should not be paid out. Anything that had been paid out has to come back into our community. So the question was, how do you clean up the mess? Not seeing any of the judges involved, I can use mess. But the problem was, what do you do once we've gotten involved? And the question was the receiver personally liable for taking actions which caused the disposition of various assets or reallocation of assets? Was the receiver responsible for restoring the funds paid to the attorneys? Was the attorneys responsible for paying all of that stuff back? In other words, if the court assumed jurisdiction over a case, and then it was found by the Supreme Court to say, no, you should not have assumed jurisdiction, what do you do? There's a long discussion in this third appeal about the fact that if you do appeal, because you assert the court shouldn't have gotten involved, and it's ultimately determined that the court shouldn't be, well, the trial court is immune from prosecution for his mistake. Merely because the judge has made a mistake doesn't mean he's personally responsible. There was nothing to indicate that there was anything improper in what had occurred. It was also then looked at, well, in the appointment of the receiver. Yes, the receiver should not have been appointed. either. But the trial court had no way of knowing that because at the time of the appointment, then there was nobody around from the Supreme Court that had told the trial court you can't go ahead and do what you've done. The receiver here also didn't pay attention to the niceties. The receiver is supposed to take an oath of office. In this instance, the receiver did not. So an allegation was, of course, raised, well, he's an improper receiver. He never, in fact, fulfilled the rules for appointment. He was not clothed with any kind of immunity because of the failure to take that oath. In this appeal, there is a fair discussion about the receiver and the appointment. And it's, not a terribly persuasive, in my view, opinion, but the court says everybody agreed on this individual to be the receiver. Other people had been suggested, but everybody agreed that this person should. Everybody agreed to what the scope of his duties should be. Everybody had agreed at every stage of the game. And it wasn't until much later that they discovered his oath had not been taken. In fact, that wasn't discovered until the time the court was trying to resolve everything that it had done. At that point, it basically was a technicality. But I think one thing that it says to me in reading that discussion is if you're going to have a receiver, read those rules and make sure every little thing is done, or you could end up with an uncomfortable, say, legal malpractice because you did not protect your receiver that you asked the court to appoint. Or that the receiver, who then of course had an attorney, I think they all do, is, maybe he would have been responsible for them. But the court saved everybody and said, no, this was all consensual, everybody knew what he had done. There were no allegations of improprieties, no allegations of bias, no allegations that he had stolen or done something. So that part was allowed to be there. The court said the unsurprising thing, which I think we all know, is the court has jurisdiction to determine the jurisdiction. That's all this case really was. From the very beginning, 3 appeals ago. I believe there's going to be a 4th appeal, but 3 appeals ago, it was just, can the court hear the case? The answer is no. Just because the court is wrong, unsurprising, the court is immune from its decisions. All acts taken as a result of the assumption are also covered by that immunity. Therefore, the receiver was clothed with immunity. Nobody could get to him. And there's just the tiniest of discussions concerning the attorney fees question. But the implication is that also will happen. But it was an unfortunate thing because they've exhausted hundreds of thousands of dollars in this litigation, and there's no way of knowing how much the community actually had, but I suspect it's significantly depleted. The court talked about and used the word improvident a number of times. I think just saying it's unfortunate, it's a mistake. Everybody gets paid as long as the original assumption of jurisdiction was reasonable in the first place. Does that mean an unreasonable assumption is not going to be covered? I think the answer is going to be no, unless there's personal bias or something there. Default judgments. Surprise, surprise, the court says yet again they're really disfavored. Sometimes clients think, great, they didn't answer. We're going to get a default judgment. We just saved ourselves a boatload of money. Well, oftentimes what happens is they come back and they go to court and you have an appeal. Maybe the trial court grants relief from the default judgment. Maybe it doesn't, but either way, you can bet that there's going to be an appeal taken. Now, these 2 cases we're going to talk about here for a few minutes are both on page 7. Egg First Farmers Co-op versus Diamond C Dairy. In the course of this litigation and discovery, an admission was made. An admission that turned out to be fatal to the case. But in the course of just before trial, it became known that in fact the admission was factually impossible. The time the statement was made, the admission was made, it was thought and believed that the admission was true. But evidence was discovered that the admission, in fact, was not true, nor could it be true. There was no scenario under which it could be true. The admission was sought to be withdrawn. The trial court said, no, you've admitted it, it's too late. Admission is an admission, and based on that admission, guess what, it had an unhappy outcome. On appeal, the court said, no, there was, with that admission, if it's factually impossible, the whole purpose of going to trial is to try a case on the merits. This admission was not true. Therefore, there could be no trial on the merits, because based on this admission, the case was lost. because of that loss resulted in default judgment, I think that's what bothered the court. That and the fact that there was just a blanket rule that, nope, admission is admission, we can't do anything about it. There was no allegation that by changing the admission, anybody would be prejudiced other than the fact that they lost the case. But there was no prejudice by going to trial. There was no problems and unfairness to anybody. It was just the truth. And the truth should trump the rules. Not surprising, but there's been any number of other cases in the past where that issue has come up. If you make a statement in your pleadings and it turns out to be incorrect, how do you undo it? This one comes closer than many of them saying, trial court, we have to allow it to be undone so that the truth can be tried. The truth of the matter can be tried and not the defaults. So this one, an admission later found to be untrue, can be withdrawn. A related default judgment case is laid down by Buckland Construction versus McCormick Construction. This one was way too difficult. Procedurally, it's a mess. The parties involved were a mess. It was really kind of an interesting thing. There were many things going on. And at some point, allegations in the nature of a counterclaim were made. Many pleadings followed, but there was no direct response to those counterclaim allegations. The time came where a default judgment was sought on those counterclaim allegations. At that point, it was sought, a response was filed that was in effect an answer to those, and it was objected that it was untimely, and therefore the attempted answer had to be stricken. The trial court agreed. Based on that, they lost on basically default judgment. And there were a number of points actually tried in the case. But on appeal, it was again the question about what's the point of a default judgment versus trial. If it's going to court, the court prefers that the matter be tried on its merits, and that if there's additional information that is relevant to it, they should be allowed. Here, the court concentrated more on evaluating it from the excusable neglect of the attorney involved. I know the attorney went, because he had answered numerous pleadings, had been involved in everything, had always been actively involved with everything. And it was characterized more as an oversight. It was an issue that hadn't come up beyond the initial filing of the counterclaim, and much time had gone by. The trial court was supposed to be more tolerant, and it wasn't just this trial court, it was directed to all of the judges, that if the choice is a default judgment or a procedural rule that is preventing the trial of the case on the merits, the procedural rule in many instances should give way. Good deal for this. At what point, we all live by the rules. We need to have some way of knowing this rule says this and this is what's going to follow. Query, are these cases in some way changing that? Are the courts being told, well, the rule might say this, but maybe there's other reasons where you ought to not apply the rule? I think we're going to have some issues down the road. There's going to be cases and the courts are going to have problems at the trial court level about when does a rule mean what it says. The admissions one is easy. These two, I think, are fairly reasonable in their outcomes, but I don't think the reasoning is confined here. I think we're going to find some problems down the road from these. Now we're going to get to a subject, class actions. All right, I have my life. I find class actions interesting. What can I say? Thurman versus Kuna Mutual Insurance Society. That one actually originates here in Rapid City. The previous two cases we talked about directed the trial courts to exercise tolerance and to be looking for what is the best, most efficient way to reach a just result. Sometimes in those previous cases, it's, the rule won't be applied strictly. But in this one, it was reached out to the question of class action certification, which is better, one lawsuit or 4,461 lawsuits, each of which were probably confined to less than $100 worth of actual damages. The trial court determined everything and determined that the class representatives, the Thurmans, were not identical to all of the alleged class participants, and concentrated on differences between the class representatives. and the rest of the proposed class. And that was found to be the wrong way of doing it. What you should really look at is, there's going to be differences. It's going to be rare where you find exactly identical things. People pay different amounts at different times. So what it was it was alleged that the Blackness Federal Credit Union unilaterally, without telling people except buried in a newsletter somewhere, had gone in and changed the cost of people's credit life insurance. So you get a home loan and you insure your loan for the outstanding balance. And that's part of your monthly fees that you pay. Well, they went in, they said it was going to be changed, but gave nobody any idea of what was going on. Well, the Fairmans came to the point where they were able to pay off their loan. Well, they had been keeping track off of their amortization schedule of what was still owed. The payoff was more than double. Well, why? Well, upon investigation, it's because the change that had been made on the insurance policy, contrary to the representation that there would be no change to the homeowner, in fact, had many times increased those monthly premiums. And of course, those premiums were being paid, so they were being amortized with the interest. So the poor Thurmans and 4,461 other people were alleged to have been harmed to a significant amount. Well, the case was reported to the proper banking authorities, and a fine was paid of over $100,000 for doing this.